Good afternoon, everyone. Welcome to our latest in a great series of lectures today. The Center for Business Law and the Law School are delighted to welcome Professor Avery Katz of Columbia Law School. He holds the Milton Handler Professorship of Law and the Reuben Mark Professorship of Organizational Character at Columbia. Earlier in his career, he served on the Michigan Law faculty, the Georgetown Law faculty, and was an Olin Fellow at Yale. Professor Katz earned both his JD and a PhD in economics from Harvard. He is one of the leading scholars of contract law in the world, and he's known for his groundbreaking work on option contracts, incomplete contracts, contract theory, fee shifting, promissory estoppel, and guarantee contracts, among many other things. His scholarship has really changed the way that we think about private agreements and the role of law in structuring economic relationships. Among his many influential contributions is his analysis of when silence in the face of an offer should be construed as acceptance, a topic that our first years will soon encounter in their contracts course if they haven't already. Beyond his foundational work in contract theory, he's also an expert in business and corporate law, transactional law, and dispute resolution. He's taught a wide range of courses, contracts, economic reasoning in the law, payment systems, commercial transactions. It's a dean's dream to have a professor willing to teach so many. And also, this is a really cool course that we would love to offer, an innovative deals course where there's some theory and a lot of practice by the students. He served for 10 years as an associate dean at Columbia Law. He has designed some new forward-looking courses on negotiation and also on contract design and analysis, one of which examined or will examine next semester Columbia University's agreement with the Trump administration. So I think that's a fascinating example of applied contract reasoning. Today he's going to speak to us on how to do things with contracts, a transactional perspective on the 1L contracts course. Please join me in giving a warm welcome.
Thank you. I wish my mother were still alive to have been able to hear that. I don't teach corporate law. I'm a fellow traveler, but I don't have expertise there. So I came to talk to you about how I teach contracts to 1L students, and also about my in-progress project to develop this approach into a book to be called How to Do Things with Contracts. And perhaps to persuade you that you might want to try to teach contracts this way, maybe even a little. So let me, is this tied to, okay. So let me tell you about the motivation of the project. So as we all know, the first year curriculum, and much of law school generally, is organized around courts and around litigation. In CivPro, you might hear a little bit about alternative dispute resolution, and the fact that it's called alternative dispute resolution gives you a sense as to how much coverage it gets. It might be that the lawyering classes might include some coverage of client counseling, even negotiation. There's some schools like Case Western that I understand you have a 5-credit 1L lawyering class, which includes more of these skills than are offered at Columbia. I think that's great. But the focus is still mostly on what happens if you go to court or if you have to go to court. And the traditional capstone of the 1L year, the capstone experiential project is moot court. It's not moot client counseling. It's not moot negotiation. The idea. So if you only attended the first year of law school, or if you only watch lawyer shows on TV, you might think that that's all there is to law is going to court. But in fact, we all know most cases end in settlement, a contract. We know that in the United States, what did I do? Okay, in the United States, for better or worse, most criminal pleas end in a plea bargain, also a contract. And most potential disputes on the civil side don't result in the filing of a complaint. I think that's probably true on the criminal side too, but I lack the expertise to assert that. And in the area of contracts, the area that I teach, The great majority of contractual relationships don't lead to the kind of grievance that requires that kind of thing. So we're looking at the 1% of the 1% of the 1% when we look at litigated cases. And again, let me remind you of the reason that we do it. If you ask people what's the justification for this, they would probably say, well, these settlements all occur in the shadow of the law. And so you have to know ultimately what would happen if you didn't settle, what's your threat point, what we in the negotiation biz call the BATNA. A negotiation takes place and the settlement takes place in the shadow of the law, and so we teach it in the following way. First, the contracts class is different. So it is the one class in the 1L curriculum where there is an opportunity for students to engage with the process of making law. Because at a law school like this, or at a law school like mine, you would look around and in a group of 100 people, maybe there will be a few people that one day will serve in the legislature. And maybe there will be a couple of people that become judges, and then they become celebrated alums and get invited back, and their portraits are on the wall. And some people will become government officials, bureaucrats, administrative lawyers. But everybody in the room, everybody who practices law, will one day be a lawmaker. So you law students who are here, you few law students here, you're going to be lawmakers, because if you draft or negotiate a settlement contract, you are making law. If you mark up a term sheet, you are making law. If you counsel a client whether or not to sign a contract, you are making law, or you're preventing somebody from making law. So you're all going to be lawmakers, and in order to be lawmakers, we should be teaching you how to do that well, how to make law, and not just argue in front of a tribunal who's going to make the law. You're going to be making it yourself, and we should teach you the basic principles of how to empower your clients to engage in self-governance. So that's the project. Let me contrast the way contracts are typically taught. So contracts is typically taught pretty much like torts, like property, like Civ Pro, the same way, according to the case method. And there's a lot of information on this slide, but there's some pictures. So you guys know about the case method. It was invented by Christopher Columbus Langdell in the late 19th century at Harvard Law School. He introduced that style of teaching focused on the study of appellate opinions. And it was still in force. Sorry, that was the previous one. It was still in force when I went to law school, although I went to law school a little later than this. And it's still in force today. Basically, this is how it's taught. And there's two standard justifications for this, which you have heard. One is the approach which might be called legal formalism, and this was Langdell's approach, which is there are a set of principles that govern the law, there are a set of rules, everybody needs to learn them, but the way to learn them, said Langdell, is not to study the rule book, which is the way that it's done in some other legal education systems, but to study a sample of judicial opinions in the same way that physical scientists infer the laws of physics and chemistry by studying the physical world. And the idea is the same thing here, except that the examples are not balls rolling down hills, they are judicial opinions. That's the data from which we infer the rules, and Langdell called it a legal science. He had that model explicitly in mind. There's another model, which you're equally familiar with, is that it's the approach that's sometimes called the legal realist approach that came into the United States in the middle of the 20th century. And the idea there is the outcome of legal cases, it doesn't depend upon rules. The rules are part of the discussion, but it depends upon a host of impressionistic factors, politics, morality, filter through the details of the individual case. And if you're a radical legal realist, you say that's all there is, and the cases are the law. And we study the cases not because they illustrate the law, because they are the law. And then the doctrine, that's just a filing system. But in both systems, The focus is going to be on written opinions of courts for these two reasons, and probably those of you that have taught in the case method and have learned in the case method are familiar with a variety of these kinds of reasons. And typically what will happen in the case method, and I do it too, is there'll be a series of conventional questions, the nature of which will depend upon the jurisprudential approach of the instructor. When I'm in legal formalist mode, I might say, what is the legal issue presented by the case, and what would happen if the facts were a little bit different, then what would be the result, or suppose the facts were framed in a different way, then what legal rule would that catch? And then if you're operating in legal realist mode, which I also sometimes am, and almost all law teachers today at American law schools teach much of the time, if not most of the time, from that perspective, they'll talk about, is it possible that this case could have been decided by a different rule, and would there be a way to frame the facts or look at different facts so that the tribunal would say, oh, it's not that rule we should apply, it's this rule we should apply. And then there has to be some account as to when there's these two warring rules. I don't have a mouse. Yikes. So I have something on here that I'm supposed to, that I can okay, so I can use that. Or if the facts were framed differently. So I'm guessing everybody here knows the case of Katsakis v. Dematsis. Anybody remember this one? Students? Bueller? Anybody? Okay, it's this case. This was a case, just to remind you. This is a case, it was in 1942 in Athens. Everybody's panicking. The Axis nations are about to invade. They've already started invading Greece, and the outskirts of Athens. And in the middle of all of this, Mr. Katsakis lends Ms. Dematsis, well, what he lends her actually is 500,000 drachma. You already have heard of this case? Okay, he lends her 500,000 drachma. And then they write a contract in which she promises to repay him $2,000 at some future day at 8% interest, which actually was a reasonable interest rate for the time. And then what happens then, oh, and by the way, the 500,000 drachmas at that time, according to the official exchange rate, which meant nothing at the time as a practical matter, the official exchange rate for 500,000 drachma was $25 American, but it was drachma, not dollars, that she needed to get out of Athens. And so she signed this to get the drachma and to get out of Athens, and then amazingly, 7 years later, the two of them encounter each other in a small courtroom in Bexar County, Texas. Okay, where's Bexar County, Texas? It's not as rural as it sounds. It's actually Bexar County, Texas, although people from there say Bexar County. It's the county that contains San Antonio, so it's not nowhere. And they find each other, and he sues her. He brings the note in for the $2,000, and she doesn't want to pay. And so he sues her, and it goes to the trial court. And the trial court, there's a question about is there a false recital, because in the contract she said that she had received $2,000, but in fact that's not true. She received 500,000 drachma. So whether there was a failure of consideration needs to be decided. But the trial court decided there was consideration, but the $2,000 was a bit too much. And so the trial court, in its Solomonic wisdom, gave an award of $750, not explaining why it was $750. And so Mr. Katsakis was not satisfied with that. So we took it up to the Intermediate Texas Court of Appeals. And the Texas Intermediate Court of Appeals said, this is a court of law. We can't have some sort of Solomonic justice. I always ask my students, how do you think they got to the $750? Oh, $750 plus 7 years of interest at 8%, so it came to be 1,100 or so. And I always ask my students, how did the trial court come up with 750? And it's usually early in the class, so they don't have the nerve to answer with the true answer, which is they made it up. But the case that I teach is it's in the appellate court, and the appellate court says no, we certainly can't have Solomonic justice in the courts of Texas. It either has to be the case that it's 0 or 2,000. Those are the only answers that are possibly consistent with the rule of law. So they give 2,000 because the issue was there consideration? Was there failure of consideration because she didn't get the $2,000? The court said, it being somewhat legal realist, well, she basically got what she bargained for. Was there consideration? And the answer, that was kind of an easy one. Yes, it was a true bargain. She got value, he got value, there was an exchange. Now, with using the legal realist thing, we said, could we make out an argument of duress? And it turns out that if you go through the elements of duress, it doesn't work. And then you can say, well, could it be mistake? Why they do it? Could it be fraud? And there aren't evidence suggesting that. And finally, unconscionability. And the answer to that is, well, I don't think that it would have worked in Texas in 1949. It's your own judgment as to whether it would work in Texas today. And then we have a little realist discussion about how this might work today if somebody made a similar promise in Ukraine or Gaza or something like that. So that's the standard way of teaching this kind of material. And it's a good, and then this is also, I ask the students, why do they think this case is in the book? And eventually one of them say, I think probably the casebook editors looked for the most outrageous, most one-sided, most unfair, most unjust contract that was ever enforced and chose it to put it in the book in order to illustrate the doctrine of consideration. I think that's correct. That's correct. But I would like to do more. I would like to do more. I mean, there's probably really nothing that could have been done in 1942 in Piraeus, Athens to meet the client's needs. She escaped with the money, but there were people who didn't get the money who didn't escape, and so that was kind of a zero-sum game. So what does this leave out? Well, it leaves out what many people call law in action, and maybe some of the students have heard the term law in action, but all the faculty have. That there is this law on the books, but in reality, it doesn't work that way because you can't prove it, or it's too expensive, or nobody wants to sacrifice their business relationships by actually suing somebody. So in reality, it works out a different way. So it leaves that out. It leaves out the possibility that there are ways to enforce contracts outside the court, such as by going to the newspapers and making the other side look bad, which can sometimes work, or by posting bad reviews on Yelp. Or actually, unusually enough, sometimes by going and having coffee with the person and persuading them to do the right thing. That's not impossible. And these are really important things that I think lawyers need to know about. It's not all about going to court. But again, what it leaves out is the forward-looking idea that you can make the law and not just figure out how to apply it after it's made. Okay. And I think contracts is the class in which one should teach how you make law. There are classes in legislative drafting and so on, but for the basic 1L curriculum, it's got to be contracts. And you would ask questions like, why would you want to create a contract in the first place? Why you design them one way rather than another? Why do you perform when things get difficult and it's not in the interest? Even if it's going to be very expensive and unlikely that you're going to get sued, still most people perform most of the time. Why? It's worth asking. And then given the costs and difficulties, if you have a client that wants to hold the other side accountable on a contractual promise, what are your options? And your options are you have options in addition to going to court, and usually you have options that are better than going to court. And then how to do this competently and sensitively and humanely. So again, it's only a 4-credit course. There's a limit, but still, I'm gonna skip for reasons of time. So these are the case books that are used by my colleagues at Columbia. This is the one that I use, Fuller and Eisenberg. And I've got a research assistant. There's many contracts case books. I've got a research assistant that's going through and checking to see what coverage they have of the kinds of issues that I'm talking about. And the answer is not much. There's a little, but typically contracts case books start one of 3 ways: with remedies and if you have a professor that has that, God love you, with offered acceptance, which is popular, and with consideration, and mine starts with consideration. And then they do the other two, and then at some point they get onto interpretation and performance and breach and things like that. So that's typically how it's taught. And if you front load consideration, and if you front load remedies, you're kind of committing yourself to the view that the most important thing that students need to know is this thing going to be enforced in court? And what remedy will you get if it is enforced in court? That's kind of implicit in doing remedies first and consideration first. And I do consideration first. I follow the book. But I think it's important to let students know that these maybe are not the most important questions, and it may be that if you are, again, issues of offered acceptance about whether people are confused about what they've agreed to, those are important questions, whatever modality of enforcement you're going to use. So if you're going to go and have a conversation and persuade the other person that they should make things right for you, you're going to need to talk about what the contract means. And you're going to need to talk about whether or not anybody thought this was actually supposed to be enforceable. So it might not be enforceable in court, but it might be enforceable in the forum of public opinion. And so the issues having to do with consideration in the courts are analogous to the questions of whether or not a contract is enforceable in the court of public opinion. Some aren't. There's some case books that do some of what I talk about, and I want to give them a shout out, and I don't want to disparage. The most famous one is the Wisconsin case book by Stuart Macaulay and his friends. And there's a case book by Schwartz and Walters, and there's a case book with a very promising title of Making and Doing Deals by Epstein and Markell. But there's not really that much in there about it, making and doing deals. It's framed in terms of you're going to be a lawyer when you get out of here, and you're going to have to solve problems, but there's a disproportionate number of the hypothetical problems in this book involve characters named Epstein, Markell, and Poneroff. So Epstein makes an offer to Poneroff, and then Markell comes in with a better offer. So it doesn't really up to the title. Although it's a very entertaining and funny book, and I understand from Foundation, it's one of their top sellers. Although I can't get data on what are the top case books. I use this book as a supplement, 3D and Miller. It's a workbook with some problems in it. I was telling Juliet and Eric about it over lunch, but it's very time consuming to use this book and give them problems. There's other pedagogical options, some of which you have here. You could have advanced experiential courses in drafting and in negotiation and in transactional practice. You can adjust the lawyering classes as you do here. There can be dedicated courses in transactional lawyering. So for example, the University of Chicago now has a required 3-hour course, but it's a trimester course, so it's really only 2 points, in which it's called transactional lawyering, and everybody has to take it in the first year of law school, but it's focused on commercial terminology and borrowing and lending and interest rate and finance statements. It's stuff commercial lawyers need to know, but it's not exactly what I'm talking about. They're great options. But my claim is this really should be integrated into students' foundational understanding of the subject. That's my claim. These are the kinds of things that I try to get my students to learn about. And I tell them to be an effective contract lawyer, there is absolutely no substitute for understanding the transaction. Let me tell you where I got the title. Where I got the title for the book. I stole it. I borrowed it. It was inspired by a celebrated book in the field of philosophy of language by J.L. Austin, the Cambridge philosopher of language. And he gave a set of lectures at Harvard called the William James Lectures. And it was published posthumously of this book, How to Do Things with Words. And the idea of so this is in the literature on linguistic philosophy, and I'll keep that short. this is credited with starting an entire branch of linguistic philosophy theory called speech act theory. The idea is that some sentences, some utterances are not like about things. They're not intended to describe things. They're not intended to inquire. They're intended to do things. They're intended to do things. Like sentences like, I quit, okay, or get lost, or please pass the salt, or I like this one, case dismissed, okay. And these sentences don't just say things, they do things. And to take the example, I resign or I quit, it doesn't just convey information about the fact that I've resigned, it actually enacts the resignation, depending upon how people take it. Compare the phrase, I'm going to resign next week, which gives information about what might happen and you better get ready, but it doesn't itself do something. And in this, so Austin argued that if we're going to understand what these sentences mean, they're not true or false. That's not the kind of sentences they are. That we have to understand the work that they're intended to do. So please pass the salt is intended to influence somebody else to do something in your favor, and you say please pass the salt because you want somebody to pass the salt. Again, you could. Such sentences could be used ironically, and somebody you might be, two people are marooned on a glacier, and one says, "Please pass the salt," as some kind of existential commentary on what's happening. But ordinarily, these are performatives. Okay, and so my view is, I think this is the way that we need to think about contracts. Contracts are not just about things that are enforceable or unenforceable, the way sentences are true or false. We really need to understand what they're for and what they are supposed to do, and so hence, how to do things with contracts. So I want to tell you about my personal journey. I never practiced law full time. I was one of these JD PhDs that went from one side of the desk to the other. And I started at the University of Michigan. I was a freshly minted JD PhD. I found out later on. Well, I'll skip that. I was fortunate enough to have a wonderful mentor, James J. White, who many of the contracts teachers will know is one of the leading authorities on the Uniform Commercial Code. And it was through teaching contracts with Jim White that I learned that insights from law and economics, which was my graduate field, were really best taught by presenting them in a transactional frame. And so let me give you an example. So who here has heard about the concept of efficient breach? Anybody heard about efficient breach? If the students heard about efficient breach? Maybe, that's fine. I wouldn't necessarily. Okay, so let me tell you what efficient breach is. So efficient breach is the idea, okay, that if the cost of performing a contract, once you've made the promise, as I sometimes summarize it for my students, it's the thesis that sometimes promises are made to be broken. If the cost of performing a contractual promise is greater than the benefit to be perceived by the promisee, it is not just okay not to perform the promise, but it is good policy not to perform the promise. And so contract law ought to be set up so that people don't perform promises that are wasteful. That doesn't mean that they should be breached. They could be, you could bargain your way out of them for consideration. There's a whole literature on this, but the concept of efficient breach was popularized by Judge Richard Posner. It actually was coined by my emeritus colleague, Bob Scott. And Bob is unhappy not to have the appreciation, so I do want to give him a shout out. But what are the asserted implications of efficient breach? Well, one is specific performance should be wasteful, and therefore it's a good thing that our Anglo-American contract law makes specific performance rare rather than usual, because if you have to perform every promise, then you could wind up promising. You would wind up performing some inefficient promises, and you shouldn't do that. It's wasteful. Also, second point, under ideal circumstances, and I mean ideal, and if we're being rigorous about this, it would take some time to spell out the conditions. But under ideal circumstances, if you set expectation damages exactly correctly, and if the party contemplating breach correctly predicts what those would be, and then there's, then expectation damages, in theory, provide efficient incentives to perform a breach, and Posner argued, and that's why we have expectation damages. I personally don't buy that, but I don't buy that last part. And again, under ideal circumstances, yes. And then if you want a fuller analysis, this is a chapter that I've written with Ben Hermelin and Dick Raswell that lays out the entire thing, because sometimes you don't just care. So expectation damages give the right incentives with regard to the performance breach decision under ideal circumstances, but they don't give the right incentives for how much to rely necessarily. They don't give the right incentives to the question of how long should you take looking around for contractual partners. But on performance breach, they're functional. So I was a first-year teacher. I actually taught this in 1L contracts. Jim White let me do it. I think on the same theory that all the teachers do. So sometimes in order to have students learn things, you need to let them make mistakes and learn from their mistakes. So I taught this, and I think I even put it on part of an exam question. I think there was an exam question that said, as a policy matter, if you could change the law so that it was reliance damages rather than expectation damages, would that be good policy? And but at some point, and the students, again, those of you in this room will have had the experience that when the professor begins talking about policy issues, that's the point at which the students put down their pens, or you probably don't use pens anymore. It's the point at which the students then, surf to something else. But I was new. I was brand new. They knew I was brand new. I had a PhD. They liked me, and who knew it could be on the exam? So they paid attention, and they even learned some of it, but they weren't really interested. Okay. At some point, I had an epiphany. And the epiphany was the following. I don't remember exactly when and how I had the epiphany. But the epiphany was the following. I said, let me tell you exactly what efficiency means. Efficiency means, so technically, efficiency is a situation in which it's not possible to make one person better off without making somebody else worse off. That's the technical definition in economics. Maybe you've heard it. So to say that a situation is efficient is that there's no way to make both people better off at once. But to say that a situation is inefficient means there is a way to make both people off better at once, or to make one person better off without hurting anybody. And so I said, so what that means is if you are ever in a situation with a client and there's a legal rule governing the situation, and the legal rule is inefficient, and you don't change that rule, you are leaving money on the table for your client. Okay? And it was amazing and gratifying how much more interesting they were when I presented it in this manner. So, it was off to the races, and I taught a bunch of other things. For what it's worth, here's how I teach efficient breach now. Okay, this is the situation. I say, you're having your steps report prepared. I mean, when I was in DC and when I was in Michigan, it was like you're having your driver. But in New York, you're having your steps repaired. And you have your choice. You can use, and it usually costs $1,000. This is what it costs, not what the price is. This is what it costs the contractor to do it. And 30% of the time, but 30% of the time there's going to be adverse conditions, like it wasn't installed right, or there's rats nesting underneath or something. And so 30% of the time, it can cost $3,000, but you can't know until the contractor shows up and starts to do it. That's the situation. And this is a heroic assumption. You know how much you value these steps being repaired. You value it as $2,000, which I admit, and I tell the students this is heroic. People don't always know what the contract is worth to them, but for the purposes of argument, it's $2,000. And what that means is, well, one thing it might mean is you've been told by a real estate agent that when you put your apartment up for sale, if you have the nice steps, they'll bump up what you can charge by $2,000. Because it has more street appeal. Or the traditional consumer economics way is you ask people, well, what would you spend the money on instead? And let's suppose for $2,000 you can have a really nice vacation at Disney World. And if it's below $2,000 and you can have the steps repaired and then you have money to spend on something else, you'd rather have that, but if it's going to be more than $2,000, you'd rather go to Disney World. Right. So that's the idea. So that it's worth $2,000. And then here's the trick. You're choosing contractors, and it used to be you look through the yellow pages, and now it's you look on the internet. And you have three choices. One is you can choose AA Excelsior contracts. This is based on an actual sign, a picture that I took in New York, and then I signed. You can choose AA Excelsior contracts, and their motto is, we always get the job done. We always finish the job. This is specific performance. We always do the job. You know, you look a little more and say, that looks good, that looks good. You see them first because they're at the middle of the alphabet. And then you look a little further and you find efficient contractors. And efficient contractors does not promise to finish the job no matter what. What they do promise is they promise we either get the job done or we will pay you your lost expectation, in this case $2,000. And they have to have some way of knowing what your lost expectation is. And let's just stipulate, let's suppose that they do it the same way that you declare the value of a package when you send it on Federal Express. They say, how much is this worth? And you say $2,000, and they set the price accordingly. And they say, we either, and then they have to make sure, as with Federal Express, that you don't over-insure it and hope it gets lost. But the idea is you can choose somebody that will do this. Or you can choose a third one, which I like to call Manhattan contractors. And Manhattan contractors does not promise to finish no matter what. They do not promise to pay your expectation. But what they do promise is that if they show up, and they don't promise to show up, but they promise that if they show up, and they'll either do it, or if they can't do it, they will clean up after themselves and like leave you. This is like Reliance damages, put you back where you were. Okay? And so in the hypothetical, you've called around for references, and these companies have a good reputation. They keep their promises. And then the question is, which one of these guys do you want to hire? You get to choose. You can choose any of them. Which one do you want to hire? And so the students will talk about this. And pretty soon, I mean, depending on how quantitative they are, pretty soon, pretty much at the beginning, somebody recognizes AA Excelsior is going to have to charge more. Because if they promise to do it no matter what, including when it costs $3,000, they're going to have to charge more. Or they'll be out of business. Okay, and how much more do they have to charge? Well, how much they mark up is a separate issue. But minimum to cover their costs, and maybe they're slow on business and they're willing to do it for below cost because they're trying to break into the market. But basically, to cover their costs, they're going to need to charge $1,600. 70% of the time they can get it done for $1,000, and 30% of the time it's going to cost them $3,000. So if they're going to cover their costs on balance, this is what they have to charge. Okay. Now the expectation damages guys, they're going to have a markup. They're going to have a smaller markup because when they don't perform, they don't ever spend $3,000 to finish. What they do is they spend $2,000 to pay you your expectation, and then you go to Disney World. And then what are their expected costs? They have to charge at least $1,300 because 70% of the time it's $1,000, and then 30% of the time it's $2,000, and that works out in expected terms. I mean, the important thing is that they charge less. And then Manhattan, again, is going to be the cheapest, of course. And then we have a discussion about which of these would you choose? Which would you want? And then I take a poll, and many students say, I would choose AA Excelsior, because then I would know I'm getting what I want. And then I would say, well, look, if you choose efficient, you're getting your expectation. And if you choose Excelsior, you're going to be asking them to spend $3,000 on something that's not worth as much to you as Disney World. And they will say, I just like to know that I'm getting what I was promised. And I say, there's nothing wrong with that. There's nothing in economic theory that says that that's the wrong answer. It's just you're paying for it. And if you want to pay for that kind of insurance, or if your client wants to pay for that kind of insurance, yeah, do it. But it's going to cost more. And if you're really in it for just the money, and you actually believe that you'll get the $2,000, you can save a quick $300 for choosing the efficient contractors, and you can save even more money by Manhattan. And when I say the students say I'd rather pay more to get specific performance, I will say, okay, what are you assuming about your budget? And they typically are assuming that they have an unlimited budget. But in real life, all of us sometimes call Manhattan contractors. And the important lesson, and this really is the most important lesson, it's not efficient breach. The important lesson of it is that you get what you pay for. And if you want to sign a contract that says you never have to mitigate damages if you don't want to, like Shirley MacLaine and Parker v. 20th Century Fox, or you can do it. You can do it. Our system will let you do it, but it's going to cost you. And you shouldn't assume that your client necessarily wants a Cadillac contract. Sometimes they want, they don't make Buicks anymore, they don't make automobiles anymore. Sometimes they want a Chevy contract. And so you need to know that. So that's okay. So here are some other ways. I'm going to stop in about 5 minutes to take questions. But let me give you a couple of examples of how I teach the following doctrines. Okay, so let me do duress and modification. Okay, so the students who are 1Ls, you've done duress and modification, yes? No. Okay, you've heard that there is such a thing as duress. Okay, so at some point before the end of the semester, and you'd better because it's going to be on the bar exam, you will learn that there are doctrines that govern when contracts can be avoided because they were entered into under coercive circumstances. And the answer is you might be able to get out of them, and you might be able to go to court and get out of them, and even if you've paid, you might be able to get out of them and then claw your money back under a restitution theory. That's going to be extremely inconvenient. And when we go through a couple of cases, and the students learn what the doctrine is, and then I tell them about the following. I give them the following hypothetical, which is based on a real problem that a friend of mine had a while ago. And my friend was an assistant attorney general in the state attorney general's office in the regulated industries part of the office, and was participating in a rate-making hearing for a public utility, think Edison or think the gas company, that had to have government approval to charge certain rates. And so the company, the public utility, brought in expert witnesses about why they should be able to charge the boon. And the state AG found an expert witness who was public-spirited, who was willing to do it for less than the expert paid by the folks on the other side, to sort of say, no, this is really what their costs are, and they shouldn't be able to charge more than this. And so they had this good witness, and they were very happy with him. But what happened was, 4 weeks before the hearing was supposed to be due, the witness, who had given the state a good price, said, you know what, this is more difficult than I thought it would be. I've used up all the hours that I budgeted, and I really can't afford to put in more hours. So I'm willing to go forward with what I have now. I don't feel that I'm not embarrassed to go forward with what I have now, but I don't think it's my best work. And I think if you will pay me more to do some more hours so I can do some more work in the next 4 weeks, I can do a better job for you. What do you do? Pay him. If you don't want to pay him, what can you do? So we talked, again, the fact that you can ultimately get something avoided in court and maybe even claw it back, not necessarily a good answer to what you do in the moment. So we talk about the possibilities. Well, they paid him. He did a great job. He did such a great job that they hired him again. And they figured, okay, he's learned it, he knows what the job is, he won't have to put in all these extra hours going down blind alleys. But 4 weeks before the hearing, he pulls the same stunt. And he says, this year was more complicated, I ran some, I need more money or I can't go on. What should I do? What can they do? And so they were annoyed with him. And so I said to the class, what would you do in this circumstance? What would you do in this circumstance? And the students will then have some creative discussion. They'll say, well, some discussions that are unrealistic. So sometimes they'll say, put him on the stand and treat him as an adverse witness. Not a good idea. Or pay him a contingent fee based on how well he does in keeping the rates down. Okay, first there's a couple of problems with that. One is because you're trying to keep rate down rather than up, how do you give him a percentage of what he keeps down? You don't know. The other possibility is, what do you do when the lawyer is cross-examined and the attorney on the other side begins to ask about his fee arrangement? Not a good look. So no, you can't do that. Sometimes they say, threaten him, say, we'll sue you. And they actually went to another bureau of the state attorney general's office, the one that enforces government contracts, and said, we're having a problem with this guy. Can somebody talk to him? Can you help us enforce our own contracts? And the other bureau said, we expect you to solve your own problems. There's other people that need us to work for them. And then they talked about, there were various other things. One possibility, the students will say, pay him, and then claw it back afterwards. And the answer in the actual case, he wanted a clause in the contract that said, and you promise never to claw it back. So what do you do? What do you do? It's infuriating. They paid him. Okay. He did a good job. It's year 3. Do you hire him? Everybody says no. But he was really good, and he knows it really well, and the court trusts him. If you're going to hire him, what can you do to keep him in line? And so there's an interesting discussion, which we don't have time for right now. I'll tell you what actually happened in the case, and then maybe I'll open it up for questions, okay? And then if anybody's interested, I can talk about some of these other things. But this conversation takes maybe 10, 15 minutes. The same 15 minutes that I would take with hypotheticals about what happens if somebody holds an anvil over your head when you go to court, what happens then? This is a more interesting discussion. What actually happened was the following. This guy, in addition to consulting on his own, had a 50% interest in a consulting company owned with another colleague of his who was a professor. And so what they did was the third year, they signed the contract not with him, but with a consulting company in which he had a 50% interest. The understanding being he was still going to do the work. He was still going to do the work. But if he pulled this stunt again, then his partner was going to be dragged in and would have to deal with it. And so implicitly, the partner was brought in as a third-party enforcer who would be very unhappy that his partner behaved in this way. And that turned out to solve the problem. They never had any problems again. Now it could be just finally by the third year he figured out how to charge his rates, and it was not necessary. But it worked, and a solution like that, this should be in your toolbox. What am I going to do? I'm gonna. Okay, so we can talk about how do you find the time. What about students who lack commercial expertise? I've got answers to those if you're curious. Let me just show you an exam that I give at the end. I actually test students on this. So here's an exam that I gave last year. It was kind of inspired by the TV show The Bear, if anybody knows that one. So sorry, where's the exam question? The exam question is: there's a lawyer who just couldn't stand the corporate law life anymore. She becomes a chef. She wants to open this high-end gourmet diner, which is kind of like a mashup of high-end gourmet and a New York City diner. She's a control freak, so there's issues about non-standard policies that will violate trade usage and surprise some customers. And obviously, the customers are not going to sue, but if you're behaving in a way that's not according to trade usage, you'll lose customers. There was an issue about problems with a lease that she was going to sign. She had some plots. She was offered a requirements contract on certain terms at a fixed price, and somebody else that she didn't have to promise to anything. There's a consideration problem there. So I won't give you the text of the question. I'll make this available. People want to see it. So here's some stuff that I actually got from students at the end of the semester. These were good answers, but this is what the students were able to do at the end of the semester. So Okay, I don't have a laser pointer here. But you can see, so this is, first of all, this chef's name is Julian Enfant, Julia Child. And so she wanted to have a julienne salad, but she wanted to make it her way. And so don't do that. They'll be confused, but I understand you need to have a distinctive name, let's call it the Kent salad. And there's a trade usage issue, and your issue about no free coffee refills in diners, that's going to surprise people. Customers will be angry. She wanted to say no substitutions whatsoever, no sending things. And so there's advice there. Here was somebody, here's another one, somebody says, okay, this is governed by the UCC, the menu's in writing, so we have the statute of frauds, but here's what you can do to balance your interest in preserving creativity. Here are some things you can do. Here are some things that she could do about the return policy. No returns unless, in the chef's judgment, it was not properly prepared. And of course, that implicates the duty of good faith. Where the students talk about that. And then here's some advice about whether or not to sign the requirements and they also talk about, they spot the consideration issue, but they also talk about, does this fit the needs of the business? I think when you go to medical school, you learn about surgery, but you don't just learn about surgery. And litigation is like surgery. It's an expensive, unpleasant, dangerous, inconvenient way of solving problems. And sometimes people do need surgery. But if we want to train physicians, we want to train them to know about diagnosis and nutrition and less invasive treatments and listening to the whole patient, and that should be a model for legal education too. That analogy, I didn't come up with an analogy in order to present it here at Case Western, but I can see that maybe this is a compelling analogy at Case Western, and I think that should be our model. So that's the way I teach contracts, and that's how I teach students how to do things with contracts. I would love to have questions. A gentleman in a sweater. That's who you're wearing a sweater. Yeah. Oh, the mic.
Hello. I recall an instance where I was one of the very few people in Ohio to have dealings with the Amish on a contract matter. So I was given this contract. I'd seen it once before, and when I looked at it, I would laugh at it, you'd laugh at it, and it's from a printer in Middlefield, Ohio, the area of the Amish. It's really like the Amish Rome.
I'm more familiar with the Amish near Philadelphia, near Lancaster.
Yes, where they breed dogs and sell them to gangs. So I looked at this. It was just one page. It had about 8 different lines that you could fill in. It was mostly a fill in the blank. Who are you? Who's the Amish person? And it's about timbering. And
timbering.
Just cutting down trees.
Okay.
And so
you may put it a little closer to your mouth.
Yeah.
That's
So I looked at it and I go, what? There's nothing about acreage, hardly any location, anything. Who would ever sign this? But then in a couple of years when I learned more about how they timber, including some property I own, which I would never let them get on, I realized this works very well for them, because if the English person, as they call them, tries to go into court with this, it's not going to be enforceable, because afterwards, there's this stunned realization that they brought a bulldozer. I didn't know that the Amish brought bulldozers. Well, they do for logging. They tore up the property. They took everything from stem to stern, including a little bit of somebody else's trees on their adjacent property line. They did not leave what they call the growth trees that 20 years later, 15 years later, would be a very good.
This is why you shouldn't deal with the English.
Yeah. Well, and so, and then they just leave, some of them leave these ruts, and they like to cut in the winter, and then rain happens and there's all these rivulets and torn up land.
Yeah. This reminds me of a case that is commonly taught in the first year, PB House v. Garland Cole, which some people may know. But yeah, definitely, yeah. So what happened?
Oh, I told him I was not going to have anything to do with that contract. I'm not going to provide any advice. Why are you asking me? It's worked for years. You know what you're doing. I would never use this, and I just don't think it's fair to the other side. I don't think it's even fair to you. But he didn't care. He just went ahead and used it and scrawled it in with some stuff.
Yep.
And then I realized, because they're petrified to be in court, they literally shake when they go in there, that over generations, they've learned to use this and just foist it upon the other side. And they just sign it. Country folks who are not Amish just sign it. And then they realize that they sold, $80,000 worth of timber for about $12,000 and damaged their land. And if they beg, they can get some straw put on there. This is. And remember, educated people, they don't think well of these contracts, but there are people out there, these little country Joes, that will foist them upon people.
Right, and then the person that signs the contract not understanding what it means is and this is what contributes to distrust between communities, right? It's a problem of cross-cultural negotiation, and the person that signed the unenforceable contract, gets a bad lesson. Now there is an issue. This actually brings up an important question, which people is, what good is this? What good is this approach for the vast majority of clients who do not have the sophistication or the resources or the privilege to hire a lawyer to help them at the transactional stage? And I take that question seriously. I take that question very seriously. And I think the answer is, those people will get in trouble, and then when you meet them at the dispute stage, sometimes you can't help them. Sometimes you may be able to help them. So that said, there are some things you can do. Because suppose you want to represent the unsophisticated and the impoverished. Suppose you want to be a public interest lawyer. You still need to know how to write a contract, because if you are going to sue a wrongdoer on behalf of that's probably going to end in a settlement, and so you need to know how to write a contract for a settlement that will work for your impoverished, unsophisticated clients. There are things that you can do in pro bono, and again, so many people who wouldn't hire a lawyer would look on the internet. And maybe they can even make their way to something that's from the state bar. And I think it's part of all of our, in every state that I know of, there is a duty to engage in pro bono work. And I think it is absolutely a great way to do pro bono work, to produce those kinds of materials to be made available for legal information for unsophisticated clients who want, so that there's something on the website that actually will give the basics. So there's things that can be done. Again, this is not a just society. It's not like, privilege. The fact that contracts don't work that well, it doesn't mean that therefore we should have everything done by government. Because of course privilege has its unfair advantage in the public sector as well. And the only thing to be done is, it needs to be part of our work to provide empowerment to everybody as much as possible all the time, which is a slow task. But I think this is an approach that I think no, it's not going to help somebody who lacked the sophistication to get into this kind of issue. But eventually hopefully this will get through the community and it will help. But again, this is the law in action point. This is the point of Stuart Macaulay in the Wisconsin school, that the law in the books, does not make its way down to everybody. It just doesn't. And we should keep this in mind when we're thinking about things like, how complicated do we want to make the rules? Do we want to make the rules so complicated that they work perfectly for everybody who's thoroughly sophisticated and can get a high-priced lawyer, or do we want to make the rules simple enough so that possibly some people can do things by themselves and they don't get in too much trouble? that's always a choice. But I think that choice should be undertaken with a perspective that we are trying to help people make law, to govern their own circumstances, and that's in the contract field. That's something that really should be a fundamental part of legal education. Time for one more? Yeah.
Go ahead.
So I was trying to think about last night your project, which is really, I mean, I think one of your large critiques is that by nature of appellate court decision making, you're always approaching, students are approaching things from the perspective at the outset, ex post.
Yes.
The contract has already been breached, the calamity has happened, the tort has been incurred and the like. And so by nature of the type of case method, we're building that in. So I try to think, but you're trying to not throw everything out, but to incorporate more of these principles.
Method, and I use a conventional case law. So what I do a lot, and so one thing I do is I flip the classroom, which is I record lecture videos of 20 minutes each, typically for each class, that basically give in lecture form the doctrinal stuff that the students need to know. And I have the students watch those before class, and then class starts, and I say any questions, and students can ask questions about the topic. And then we do the cases. And what I do is I treat the cases as autopsies. I say this is a case that went to court and that was a failure, but let's figure out what happened and why. Why did they make the choices? Why did they make this promise in the first place? Why did this person trust them? What were they trying to do? What might they have done instead? And so I take, and then what are some facts that we don't know? Are there things that might have motivated them that aren't mentioned in the case? And there always are. And there's a wonderful book called Contract Stories, which some of you may know about, which it provides elaborations of what was underlying the facts of some very famous cases. And often the cases it's quite different from what happened. So there's a famous case called Mills v. Lyman, in which a young man, a ne'er-do-well young man, stays at an inn, at a tavern, and he dies, and the tavern owner writes to the person's father and says, "I've got your son," and then he dies, and the tavern owner writes to the son's father with some money and says, "I regret to inform you of the death of your son, and I spent all this money taking care of him before he died." And the father, who was feeling very bereaved at that point, says, I'll pay for what you've spent. And then he thought better of it, according to the court. And then he didn't want to pay. And so the tavern keeper sued him on what is sometimes called a theory of moral consideration. There are a few cases in which you can sue on a promise for things done in the past. Very, very few. And there's an interesting case discussion. The interesting thing, if you read Contract Stories, what you learn is something that the judge didn't know and the lawyer seemed not to know, and that much of the commentary didn't know, which is that actually the son didn't die. He was recorded in public records going around creating mischief. 20 years later, he didn't die, which might be the reason the father didn't want to pay. But in any event, this entirely escaped the court. Nonetheless, it stands for the proposition that moral consideration is available. Because I love it. If the students are looking for light recreational reading during winter break, it's maybe that's not what you want. But yeah. So you have to be, if you use the case method, you have to be willing. I mean, you don't have to do what I do, but I do it a lot, and that's because I flip the classroom and I give them. But I do spend a fair amount of time on these transactional hypotheticals that just, if you're in the middle of it, what do you do? And in my experience, that's not something that gets, but it's very rewarding. I can stay.
No.
So, thank you. This was really, really insightful.
So you can get access to the entire presentation, and you can see how I teach offered acceptance and those other things.
Thank you so much. This is very helpful.
He has to go in 5 minutes.
Okay, so we'll make it quick.
I'll make it very quick. So I guess, most theories trying to justify contract law, the question that they ask is what is the justification for the state, and by the state they mean the courts, to intervene in contract, to enforce contract, right? This is to enforce contract.
And to fund itself with resources taken from taxpayers ultimately.
Exactly. And so perhaps the reason why we use the case method is not because cases illustrate the law or because they are the law, but because of these fundamental facts that it is the core of justification of contracts is the enforcement of courts.
That's part of it. That's part of it. I think yes, when you're teaching contracts, students should be exposed to and should understand what are the reasons that we have this system and how might we critique it socially. But I think we have a responsibility also to tell students, look, this is a tool of empowerment, and this is a tool of empowerment for your potential clients, and don't waste it. I'm not averse to teaching some of those things. That's actually not the top of my personal priority list, but for sure. But don't forget about teaching students when they're good.
Okay, I have a question which is really quick.
All right.
And here it is. With respect to your witness, your expert, seems like a really hard case for economic duress, correct? I mean, no reasonable alternative, lots of people are experts and so forth. Yes, he's a good expert, he's done a good job.
Oh, if you wanted to sue him, could you get the money back?
No, it's not, it's a bad case for duress, for proving that, right?
Yeah.
But maybe it shows you that they value, they keep hiring him.
Yeah.
He keeps raising the price. They could try to ruin his reputation. They're not doing that, right?
Correct.
And they are, so it seems as though a modification, this is an appropriate case for a modification because they have been underpaying him, right? Or something like that.
Well, I think it's reasonable, and it took 3 years to figure this out, but I think if we think of this from a negotiation point of view, we would say, look, there's a substantive problem here, is that you're doing this for the first time, it's a complicated task, you're not really sure what your budget is.
Right.
On the other hand, we're a state agency, we have a limited number, we have to make our budget cover all of the cases for all the experts. Can we come up with some compensation system that will work, that will, like maybe going forward, I don't ask this question, but going forward in advance with other experts, what can we do to deal with experts who, what should governments do when they're offered a contract that's too good to be true? When somebody underbids and you know it's too low, and you shouldn't take it. You shouldn't take the lowest bid. Maybe there's something that I cite in the thing that I circulated where there's a famous New York City real estate baron. Fishman was his name. I can't remember his first name. And he said this was listed in his obituary in the New York Times. In Tishman's obituary, it said Tishman always used to say, "Always leave something on the table for the other guy."
Right.
Okay, because circumstances change, and if you take everything and you leave the other person with a smidge, then there is just going to be too big a chance that circumstances change, and then a smidge is no longer worth it to them, and then they start being very recalcitrant, and it's not worth it. Most to the extent law students are taught drafting, they're taught, take everything and write it in favor of my client. Not a good idea. We all know lawyers who do that. It's not a good idea. You want to make sure that you do the important things in favor of your client, but you don't want to leave the other side with no reason to cooperate unless they're going to be sued. And that's an important lesson which can be taught and should be taught.
Okay, on that note, I think we have to let Professor Katz go.
Well, I was worried about how I was going to talk for 40 minutes, and I shouldn't have been worried.